Hello everyone, welcome to the Blind Intelligence Show, where the rules, the rights, the responsibilities put you back in control. I am your host Foresight, and today I would like to talk about something that I don't hardly ever talk about, and my subject matter today is going to be about what happens when the summons come in the mail because you owe a debt, and it's a debt junk buyer, right? So what's the next level? Because there's levels to this. So we're going to go into it, but first let me put out the disclaimer. This is not legal advice. This is not financial advice. I do not offer legal advice, and I do not offer financial advice. If you would like legal advice and financial advice, then I suggest you find yourself a competent professional, and please be advised. What I'm about to say here is strictly for education and informational purposes only, and the views and opinions of me, the host, Foresight, does not reflect any of the views and opinions of any platform that hosts Blind Intelligence. Now, my question today is, what happens when it gets to court? Right? You get a summons in the mail. Right? You answer in the summons. Okay, check this out. We're not going to, look, I always say you should never get to court. You know, you get a summons in the mail, maybe because you didn't answer the letters, maybe no letters came. Well, that's spilt milk we're not going to discuss. But what we are going to discuss is the summons. Now the summons, they took it to another level. They done took it down. You got a summons. The sheriff came to your house, to your apartment, wherever, or to your job, and they put the summons in your hand. Now you got to come to court. Right? Now, that's level one. The next level is one of the strongest levels that'll shut this whole case down. But it's totally up to you. The next level will shut this case down when you're dealing with debt junk buyers. And here it is. You have to file an answer in that summons. And that's your key. That's your key to unlock this door, to get this mess off of you. Because it's stressful, and I understand that. But this is how we do it. You have to know the consumer law. You need to know the Fair Debt Collection Practices Act. Because under 15 U.S.C. 1692G, that talks about validation. And that means, in that clause it says they must cease all communications. If you add those admonitions to that answer, they may not even show up to court. They may not. But they may not show up to court. Why? Because they know they don't have no evidence. They don't have the evidence that they have to assert to collect the money, because now they see that this is somebody, according to your answer, they know now that they're dealing with somebody that knows what they're doing. And this is what you want to show them. You got to come up out of your fears and your doubts. Consumer law was written by Congress, and they must follow it. The judge knows the law. They deal with this all the time. But according to procedure, they got to hear these cases. They don't want to deal with this mess. They got other cases they got to deal with. When you coming in and you filing your answer like that, you helping them out. They can go on to the next case. Next. Because, like I said, it's frivolous. The debt junk buyer is trying to extrapolate money from you, out of you. For what? For what? Because that's what their business is. To get money out of you. But you got to remember, he who asserts have to prove their case, not he who denies. When you file that, you just go up there. You just say something like, "Yeah, I'm the holder in due course," or whatever you want to say, or "I'm here on that matter, concerning this case. I'm pro se litigant," whatever the case may be, whatever you want to say. State your full name, whatever the case may be, or you could say, "I'm the holder in due course, third party intervener making a special appearance for the defendant." You could say something of that nature. You know what I'm saying? Because, or making a special making a special appearance for, your name in all caps. Something like that. But point is, you want to say, all you have to make your presentment. Boom, and sit down. Don't say nothing else. Be quiet. Let that attorney talk. Don't interrupt. Don't go into dishonor or no type of way. Let the attorney talk. When that attorney comes in, they're going to come in with all types of paperwork. Now, they're going to have to come in with an assignment that they own that debt. That's the key. Key number one, the assignment, that they own the debt, that they bought that debt from that creditor. Number two, they got to have a contract with your signature on it. That's number two. Number two, right? Alright. Now, but they're not going to do that. They're going to come in with an affidavit. An affidavit, sworn testimony, signed by whoever. But that attorney don't have first-hand knowledge on that. They wasn't there when that affidavit was made up, or when you sign a contract, or any of that stuff. And now, next step, after he finished with all that mess, bringing in all those types of documents, if those not the documents that I talked about that he's supposed to bring in, if you don't bring that in, you need to object to all of that. Object to any document he bring in, including the affidavits. Objection, Your Honor. I cannot cross-examine an affidavit. I have a right to face my accuser. And you do. You do. If you giving sworn testimony, I have a right to cross-examine. I have a right to ask questions. Alright. So, objection. And I'm asking questions. I'm asking questions to the now. If the judge allow it, now sometimes the judge may allow it, they may not. Because a lot of times they tired of it, because they tired of dealing with these cases. They got thousands and thousands of cases stacked on the floor that they got to go through. So, no. So, that attorney, I'll object. If that judge allow it, then I'll start asking questions. The question is, do you have first-hand knowledge? Do you have my signature? Are you hired by the alleged creditor or the alleged debt collector? Is your company hired? Those type of questions I'll be asking. Ask questions. Don't answer no questions. Ask questions. If they ask you a question, answer a question. Ask a question with a question. Because now they're gonna have to answer you. And don't admit to anything. Because once you admit to it, boom, they got you. Off the rip. They got you. You go to start admitting and saying, oh yeah, I did, I remember, this, that, whatever, they got you. It's like playing basketball. The ball is in your court, you dribbling the ball. And then here you go make a shot and they go. Come on, man, same thing. That's what happens when you admit to when you start making these, you start you start admitting to stuff. No. It's an alleged debt. Because just think about it for a minute. If you pay them and the creditor finds out, the creditor could come after you. Now you got double dipped. Right? Alright. Now, move to a motion to dismiss. Move to motion to dismiss, and for that creditor to block because you're gonna put that in your answer. For that, move for a motion for dismissal, and for that creditor to remove anything that's on your credit report. For that debt collector to remove anything that's on your credit report. Oh yeah, because they're going to try to put some on your report. So this is what I'm trying to get you to see. This is exactly what I'm trying to get you to understand. But let me tell you this. On a lighter note, I want to talk to you personally. Well, yeah, personally, on a personal level, because see, all of this is wonderful. Having knowing what to say in court, knowing what not to say in court, but when you ain't prepared and you're afraid, when you're afraid, you got to get that under control. I know it's new. I know it's new to you. You done took off of work. You gotta find somebody to watch your kids. You gotta go to court. What am I gonna say? What am I gonna do? This is the reason why I tell you to follow the consumer law under the Fair Debt Collection Practices Act. You need to know that. You got phones, you got tablets, you got computers, you got laptops, you got, you got all these different devices, Apple Watches and Apple Watches and all this kind of stuff. And you mean to tell me you can't pull up the Fair Debt Collection Practices Act and understand what that consumer law is and read it for yourself? And if you don't understand one word in it, to go look it up in a Black's Law Dictionary. If you're not trying to invest in yourself that way. Investing in yourself is putting in the time to make yourself better. And this is the way you do it. And come out of your head. Come out of that part of your head. The fear part. And come into the logic side. And fight these people. What the guy said in the movie, oh goodness gracious. Rocky when when Rocky was trying to fight Drago, when Paulie said, "Bust this guy's teeth out." Yeah. That's the only thing that came to my head when I thought about. That's why I paused. Bust their teeth out. Bust that attorney's teeth out with consumer law. I think I'm gonna start using that. That sounds. Hey, look. If that's gonna get you up, yo, get up. Bust this guy's teeth. Bust their teeth out. Use them consumer laws. That judge gonna sit there like this. I don't care who they is. This right here is for you. You know what I'm saying? This is how you got to get control of your emotions. Because if you don't have control of your emotions at home, you're not going to have control of your emotions in court. And that can see that thing can swap and change real quick. It can go from scared to angry, like that. Because if that attorney start yelling at you, it's going to make you angry. You can get angry, and see, all of that creates anxiety, and you have to have control. You have to have control. You know how they say, this is my story and I'm sticking to it? It's real. But in this case, the Fair Debt Collection Practices Act is your story. Stick to it. Don't allow them to make you say, yes, I owe it. Because that's their psychology. Those people are counselors. Why do you think they call them counsel? So, but I'm your host, Foresight. I don't know very much, but I do know consumer law. Give me a message at blindintelligence718@gmail.com and stay encouraged.